Hello friends, welcome to our channel. Friends, today we will see multiple choice questions of Evidence Act. Friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. So friends, we will see question with answer. Question number 1. Public documents are mentioned in. Answer is section 74 of Evidence Act. Question number 2. Documents which are not covered under section 74 of Evidence Act are called. Answer is private document. Question number 3. Maxim. Maxim means omnia pro issuanter right esse acta means. Answer is all acts are presumed to be rightly done. All acts are presumed to be rightly done. Question number 4. Admissibility of electronic record has been prescribed under section. Answer is section 65B of Evidence Act. Question number 5. Principle of omnia pro issuanter right esse acta is contained in. Answer is section 79 of Evidence Act means all things are presumed to have been done rightly. Question number 6. Accused wants to submit the document for consideration under section 35 of the Indian Evidence Act. In which of the following cases will the document become irrelevant? Answer is it is not an entry made in public or other official book, register or record. Question number 7. A party wants to set aside a judgment under section 44 of the Indian Evidence Act. In which of the following circumstances can he do so? Answer is in case the judgment was passed by a superior court. Question number 8. According to section 61 of the Indian Evidence Act, answer is the contents of document must be proved either by primary or secondary evidence. Question number 9. Definition of secondary evidence has been given under section dash of the Indian Evidence Act. Answer is section 63. Question number 10. Illustration. B, an accused wants to submit carbon copy of the suicide note as a secondary evidence. The original is with the opposite party and he has failed to produce the same. The suicide was not within the knowledge of the accused prior to the receipt of carbon copy. Which of the following statement will hold true for the case? Answer is the evidence can be admitted as it satisfies the requirements of both section 64 and section 65 of the Indian Evidence Act. Question number 11. According to section 65 of the Indian Evidence Act, the secondary evidence can be admitted in dash exceptional cases. Answer is 7 exceptional cases. Question number 12. Which of the following sections of Indian Evidence Act gives provisions regarding proof as to electronic signature? Answer is electronic signature under section 67A. Question number 13. Which of the following section of the Indian Evidence Act deals with proof of other official document? Answer is section 78. Question number 14. Which of the following section of Indian Evidence Act has been amended by the Criminal Law Amendment Act 2013? Answer is section 119. Question number 15. Which of the following statement hold true for section 154 of the Indian Evidence Act? Answer is the court can give the leave under this section suo motu. Question number 16. Which of the following questions is proper under section 148 of the Indian Evidence Act? Answer is if they are of such nature that the truth of the imputations touches the credibility of the witness. Question number 17. During the cross-examination of the witness as to previous statement made before the police, almost all contradictions or omissions were brought on record, which were portions from the statements made before the police that were not deposed before the court. Which of the following statements will apply to the case? Answer is, the credibility of the witness has not been impeached because the contradictions were not as contemplated under section 145 of the Indian Evidence Act. Question number 18. A person summoned to produce a document. Answer is, does not become a witness in the case unless he is called as a witness. Question number 19. Which of the following statement hold true for examination in chief of a witness? Answer is, it must only relate to relevant facts. Question number 20. Dash. Section of the Indian Evidence Act was inserted by the Criminal Law Act, Amendment Act 2013. Answer is section 53A. Question number 21. An admission is not relevant in a civil case if it is. Answer is, made under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Question number 22. Opinions of an expert expressed in a book commonly offered for sale cannot be proved by the production of such book. Answer is, if the author has gone abroad on vacation. Question number 23. Which of the following section of the Indian Evidence Act does not apply to interrogation by a custom officer exercising power under section 171A of the Sea Customs Act? Answer is section 132. Question number 24. Which of the following section prescribe the method by which signature can be proved? Option is section 45 Indian Evidence Act. Option B section 46 Indian Evidence Act. Answer is both. Both option A and option B means section 45 and section 46 Indian Evidence Act. Question number 25. An attesting witness is. Answer is C. Both A and B means option number A, one who signs his name to an instrument at the request of the party or parties for the purposes of proving or identifying it. Option number B, a witness who has attested the document. Question number 26. Admissible evidence is thus that which is. Answer is option number A, relevant. Option number B, not excluded by any rule of law or practice. Question number 27. A is accused of a crime committed by him at Calcutta. He produces a letter written by himself and dated at Lahore on that day and bearing the Lahore postmark of that day. Applying section 21 Indian Evidence Act, which of the following is possible? Answer is the statement in the date of the letter is admissible because if A were dead, it would be admissible under section 32 clauses 2. Section 32 clauses 2. Question number 28. A is tried for a riot and is proved to have marched at the head of a mob. Applying section 9 Indian Evidence Act. Answer is the cries of the mob are relevant as explanatory of the nature of the transaction. Question number 29. A sculptor agrees to sell to B all my modes. A has both models and modeling tools. Applying section 98 Indian Evidence Act. Answer is evidence may be given to show which he meant to sell. Question number 30. In criminal cases under section 54 Indian Evidence Act to prove that the defendant committed the crime charged, evidence may not be given that he, option A, bore a bad reputation in the community. Option B, has a disposition to commit crime of that kind. Option C, had no other occasions committed particular act of the same class evincing such disposition. Answer is all of them. Question number 31. In which of the following proceeding of domestic tribunals and departmental inquiries the Indian Evidence Act is not applicable? Answer is option number A, officers conducting departmental inquiries. Option B, departmental proceedings. Option C, disciplinary proceedings tribunal. Answer is all of them. Question number 32. Relevancy of facts forming part of same transaction is dealt under which of the following sections of the Indian Evidence Act? Answer is section number 6. Question number 33. Section 132 of the Indian Evidence Act does not apply to a statement made by a person during an investigation under which section? Answer is section number 161 CRPC. Question number 34. Section 31 Indian Evidence Act declares, option A, that admissions are not conclusive proof of the matters admitted, but they may operate as estoppels. Option B, unless admissions are contractual or unless they constitute estoppels, they are not conclusive but are open rebuttal or explanations. Answer is both option A and B. Question number 35. Section 65 Indian Evidence Act, with which of the following situations under which secondary evidence can be given? Option A, when the original is shown or appears to be in possession and power of the person against whom the document is sought to be proved. Option B, when it is in possession or power of any person who is out of reach or not subject to the process of the court. Option C, when it is in the possession of any person legally bound to produce it, but he fails to produce it after the notice mentioned in section 66 Indian Evidence Act is given to him. Answer is both, all of them. Option A, B, C, all of them. Question number 36. The defense of LL.B is best because, answer is, if the accused was not there when the deceased was murdered, he could not have murdered her. Question number 37. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold. Applying section 92 Indian Evidence Act. Answer is the fact that land not included in the map had always been regarded as part of the estate and was meant to pass by the deed cannot be proved. Question number 38. The history sheet of an accused person kept in the police station is not a man's character, as it is based on. Answer is hearsay. Question number 39. The principle on which a dying declaration is admitted in evidence is indicated in legal maxim. Answer is nemo meritorius prosumitur mentor. Question number 40. The principles of section 44 Indian Evidence Act cannot be extended to which of the following? Answer is misrepresentation or undue influence. Question number 41. Section 15 Indian Evidence Acts deals with a particular application of the general principle laid down in. Answer is section 14 Indian Evidence Act. Question number 42. The question is whether A poisoned B. Applying section 6 Indian Evidence Act, which of the following facts can be relevant? Answer is the state of B's health before the symptoms ascribed to poison and habits of B known to A, which afforded an opportunity for the administration of poison. Question number 43. To invoke the doctrine of estoppel, which of the following conditions must be satisfied? Answer is option number A, representation by a person to another. Option B, the other shall have acted upon the said representation. Option number C, such person shall have been detrimental to the interest of the person to whom the representation has been made. Answer is all of them. Option A, B and C. Question number 45. Under section 82 Indian Evidence Act, the court must presume. Answer is option number A, that the seal or stamp or signature is genuine. Option B, that the person signing the document held at the time when he signed the judicial or official character he claims. Answer is both A and B. Question number 46. What do you understand by libelous character? Answer is constituting or containing a libel. Question number 47. A dying declaration to be admissible. Answer is may be made either before a magistrate or a police officer or a doctor or a private person. Question number 48. Declaration in course of business are admissible. Answer is under section 32 subsection 2 of Evidence Act. Question number 49. Declaration as to custom are admissible. Answer is under section 32 subsection 4 of Evidence Act. Question number 50. Under section 32(4) subsection 4 of Evidence Act, the declaration. Answer is as to public rights and customs are admissible. Question number 51. Opinions of experts are relevant. Answer is under section 45 of Evidence Act. Question number 52. Under section 45 of Evidence Act, the opinion of expert can be for. Answer is neither A nor B. Question number 53. Under section 45 Evidence Act, the opinion of expert can be on the question of. Answer is foreign law. Question number 54. Opinion of an expert under section 45 of Evidence Act. Answer is option number A is a conclusive proof. Option number B is not a conclusive proof. Option number C is supportive and corroborative in nature. Answer is either A or C. Question number 55. A disputed handwriting can be proved. Answer is option number A by calling an expert. Option number B by examining a person acquainted with the handwriting of the writer of the question document. Option C by comparison of the two admitted and disputed handwriting. Answer is all of the above means option A, B and C. Question number 56. The res inter alia acta is receivable. Answer is under section 46 Evidence Act. Question number 57. Entries in the books of accounts regularly kept in the course of business are admissible under section. Answer is under section 34 of Evidence Act. Answer is irrespective of whether they themselves create a liability are not. Question number 58. When the court has to ascertain the relationship between one person and another, the opinion of any person having special means of knowledge and expressed by conduct is admissible. Answer is under section 50 of Evidence Act. Question number 59. The relationship in section 50 of Evidence Act means. Answer is relationship by blood or marriage or adoption. Question number 60. Opinion as to relationship of marriage under section 50 of CPC. Answer is neither admissible in cases of offences against marriage nor in proceeding under the Indian Divorce Act. Question number 61. Oral evidence under section 60 of Evidence Act may be. Answer is direct only. Question number 62. Contents of a document under section 59 of Evidence Act. Answer is cannot be proved by oral evidence. Question number 63. Contents of a document may be proved under section 61 of Evidence Act. Answer is either by primary or by secondary evidence. Question number 65. Secondary evidence of a document is admissible as a substitute for. Answer is admissible primary evidence. Question number 66. The circumstances under which the secondary evidence is admissible have been enumerated in. Answer is section 65 of Evidence Act. Question number 67. Secondary evidence is admissible. Answer is where the non-production of primary evidence has been accounted for. Question number 68. Oral account of the contents of a document is admissible. Answer is when given by a person who has seen and read the document. Question number 69. A document required by law to be attested can be proved under section 68 of Evidence Act only. Answer is by calling at least one of the attesting witness. Question number 70. The calling of at least one attesting witness to prove a document under section 68 is not necessary. Answer is when the document other than a will is registered under the Indian Registration Act 1908. Question number 71. A will is required to be proved by calling at least one attesting witness. Answer is option number A, when it is registered. Option B, when it is unregistered. Option C, when it is admitted. Answer is all of the above, means option A, B and C. Question number 72. Section 79 of Evidence Act applies to. Answer is option number A, certificate issued by government officer. Option B, certified copies issued by a government officer. Option C, other document duly certified to be genuine by government officer. Answer is all of the above. Question number 73. Section 79 Evidence Act contains. Answer is a rebuttable presumption of law. Question number 74. Section 79 to 85 Evidence Act contain. Answer is rebuttable presumption of law. Question number 75. Presumption as to the accuracy of maps and plans made by the authority of government is contained in. Answer is section 83 of Evidence Act. Question number 76. Under section 83 of Evidence Act, presumption as to accuracy of maps and plans can be raised in respect of. Answer is maps and plans made by the authority of government. Question number 77. Which of the following section of Indian Evidence Act does not apply to interrogation by custom officer exercising power under section 171 A of the Sea Customs Act? Answer is section 132. So friends, thank you.